Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we always have a packed agenda of issues to discuss. Tonight is no different. I want to begin by welcoming all of our viewers who are joining us on television from region number 5 and region number 6. Welcome to another program of Issues in the News. To our listeners who are joining us on Freedom Radio from Robb Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the tens of thousands of you who are joining us on Facebook Live right across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, and beyond. Welcome to another program of Issues in the News. I see over a couple hundred of you are already on. Basil Sarju, Puran Singh, Pandey Vivek, Ali Ahmad, Daisy Petal Jawahir, Bud Wahid, Mala Ramnath, Leslie Mongal, Esme Kingston, Basil Siraj. Welcome, welcome all of you to another program of Issues in the News. Please share the program. Press the share button on your phone, on your computer, on your iPad, or whatever device you are using to view the program. Share it widely so that all your friends and all your followers can join us in this tonight's discussion. The more you share it, wider is the audience and greater the opportunity for discourse. I want to also encourage you to use the comment section to voice your views, ask your questions, pose whatever queries you wish to pose, and if I get the time, I'll try my best to engage you. As I said, I would like this program to be as engaging as possible. So engaging and engagement is a two-way street. So you have to engage with me so that I can reciprocate. So please let me see your questions, let me hear your queries, let me read whatever issues you may wish me to address, and use the comment section of the platform to register those inquiries and questions. And remember, share the program so that all your friends and all your followers can join us in tonight's discussion. So let's begin. Now, I have seen in the press views being expressed, misleading information being peddled regarding the summoning of Parliament. It is common ground that Parliament was dissolved for us to go to the elections. And let me make it extraordinarily clear that the Constitution enshrines in fairly clear language that the power to dissolve Parliament and the power to summon Parliament resides exclusively with His Excellency the President. I see all manner of views being expressed. The power to dissolve Parliament and the power to summon Parliament after the dissolution are powers that are vested exclusively in the President by the Constitution. The instrument by which Parliament is dissolved and by which Parliament is summoned is called a proclamation. And as I said, it is issued under the hand of the President. Now, the 12th Parliament was dissolved on the 4th day of July, 2025 by a proclamation issued by President Dr. Mohammed Irfan Ali. The RDCs of the country were similarly dissolved by a proclamation issued by His Excellency the President of the same date. Article 69 of the Constitution speaks to the summoning of Parliament, and it says, each session of Parliament shall be held at such place within Guyana and shall begin at such time, not being later than 6 months from the end of the preceding session if Parliament has been prorogued, or 4 months from the end of that session if Parliament has been dissolved, as the President shall appoint by proclamation. Fairly straightforward and clear English language. This Parliament, the 12th Parliament, was not prorogued, so the question of prorogation does not arise. The 12th Parliament was dissolved by His Excellency the President on the 4th day of July 2025. And the Constitution says that it must be summoned 4 months from the end of that session if Parliament has been dissolved. So it's 4 months from the 4th of July, and that will take us somewhere by the 3rd of November 2025. The President has spoken on this matter, and he has said that Parliament will be summoned within the constitutionally prescribed time frame. The President was referring, obviously, to Article 69 of the Constitution, which permits Parliament to be summoned within 4 months from the date that it was last dissolved. And that date, as I mentioned, is the 4th of July 2025. So I hope that the simple explanation will put that matter to rest. It is already in the it's reported in the press that a minibus driver yesterday morning collided with the median on the eastern approach road to the new Bharat Jagdeo Demerara River Bridge. The driver is hospitalized and some damage was done to the infrastructure. I see many Facebook posts being published about this unfortunate accident, and the question that is being asked repeatedly by some of these commentators is whether the government, through the agency of the Attorney General, would respond the way that the Attorney General responded when similar destruction of public property took place. Let me assure you that our government acts in an even-handed manner. If we are committed to a course of conduct, then we are committed to it. And once we are committed to that course of conduct, then whoever it is, the treatment will not be different. Equal treatment is part of the constitutional protection accorded to every Guyanese citizen. The matter is being investigated by the police. A report obviously is being compiled. The damage done to the public infrastructure is currently being assessed, and inclusive in that assessment, obviously, would be the cost of reparation. Once that information is compiled, it will be transmitted to the Attorney General office, and a letter will be dispatched, as was done on previous occasions, directed to the person believed to have caused the damage, requesting compensation. And if that letter is not satisfactorily responded to, then other legal proceedings will follow. That is the approach which was adopted on previous occasions, and it yielded the compensation that was requested, and the public property was restored, and the government coffers received that compensation. No different approach would be taken here, because our government made a public commitment to go after persons who wantonly, negligently, and recklessly destroy public property. So I just want to say that for those who are asking whether some different treatment will be meted out to this particular motor user, I don't know, or road user. I don't know why they believe that some form of different treatment is expected to be meted out to this particular individual. Viewers would recall that in November of 2024, Melissa Atwell, who describes herself as some type of social media influencer, made a series of inaccurate, false, libelous, and scandalous posts and commentaries about me. She accused me of a number of wrongs. She accused me of committing a number of crimes, including stealing, murder. She accused me of betraying my colleagues at cabinet. She accused me of divulging confidential information about my colleagues to her. And you would have read the gamut and heard the plethora of what she accused me of. You would also recall that I went on television, I came on this program, and I demanded of her any evidence that she may have that connects me to her. I even challenged her to show that we know each other. And I say here right now that I don't know this individual, and she doesn't know me. I know of her and she knows of me. There is a material difference. I asked her to make public how is it that I communicated this great volume of information to her. I asked her to name any person through whom I am sending this information. I asked her to produce any evidence that I transmit any type of information to her. Obviously, she was unable to do any of those things, to produce any of this evidence. But while I was speaking about this matter, she continues to libel me. I instituted legal proceedings, and during the course of the proceedings, when I made the proceedings public, she continued to libel me. Well, I always say that the law may be slow, but the law is not an ass. I always say that the arms of the law are very long. Recently, the proceedings before the High Court of Guyana against Melissa Atwell, filed by me, were concluded, and a High Court judge awarded damages in my favor to the tune of 37 million Guyana dollars and costs in the sum of 500,000 Guyana dollars. Now, this individual boasts on a regular basis that these judgments will never affect her and that these judgments in Guyana can't be enforced in America. She was even saying at the time that she cannot even be sued in Guyana because she's not in Guyana, she's not making these publications in Guyana. Obviously, she's ignorant of the law. So just like how she will now learn that you don't have to be in Guyana to be sued, and you don't have to be in Guyana for judgment to be granted against you, she will also soon learn that these judgments are not as impotent as she thinks they are, because in due course, very shortly, this judgment will be transmitted to my team of lawyers in the United States of America with firm instructions from me that the judgment be registered and be enforced in the United States of America. Of course, later tonight she will come out and libel me again, and I don't have a problem filing another set of proceedings. But she will come out and say that she doesn't have a cent in her name and she doesn't own any property in her name, and that may be so. And this judgment will ensure that that remains like that. Because a cent that goes into her bank account, or anywhere she has money or property, this judgment will be enforced against that money or that property. And I don't necessarily want anything from it. The lawyers in America will take their pay, even if we have to get $1 per day, they're going to get it. Because the law must never be allowed to appear incapable and impotent to address an illegality. This person has done tremendous damage to people's character, people's reputation, people's family life, and a lot of damage has been done and continues to be done. There are proceedings that are being filed elsewhere, but I choose Guyana. And I will demonstrate that Guyana's judgment is equally enforceable as any judgment obtained in the United States of America. And this must be a learning experience for all of us who believe that we can be in a foreign country and do what we like and say what we like and libel people as we wish, and we are somehow immunized and insulated from the laws of this land. Guyana is part of the modern world, and there is no legal system in the modern world that is so incapable that it cannot protect the rights and freedoms of the people who live in that society. When the parliament is summoned, we will take to the parliament the new set of laws, the new cybercrime amendments that we have already prepared and that are keeping with the protocols established by the United Nations. We had said that before, but that is in train and that will come soon. So nobody can accuse us of enforcing laws that doesn't meet international standards. The laws that we are going with are laws that have been approved by the United Nations and supported by some 180 countries across the globe. But I'll speak about that a little later. You have seen that we are making rapid progress in relation to the fourth law school of the Council of Legal Education that is scheduled to be constructed here in Guyana at the Turkine campus of the University of Guyana. I had shown some pictures of the site, and you would have seen from those pictures how overgrown the bushes were and how thick the vegetation was at that site. And we have since commissioned the clearing of the site, and you saw a video which I posted Sunday last, and how clear the place is. So we are moving a little slowly, but surely we are moving ahead and we are progressing, I think, reasonably well. And you will hear more about the construction of that facility as we move along. I want to reiterate again that this institution will be a law school of the Council of Legal Education. They will manage it, they will appoint the staff, and they will be responsible for the day-to-day running of the institution in the same way that the other law schools in the region are being managed. They are being managed by the Council of Legal Education of the West Indies. Not Trinidad government, for example, in relation to the Wooding Law School, or the Jamaican government in relation to the Norman Manley Law School. They are all run by the Council of Legal Education. The Guyana Law School, or the law school that will be located in Guyana, will be no different. You would have read in the news that despite a scathing rebuke issued by the Court of Appeal of Guyana in its judgment in the case of Crystal Fisher against the Guyana Elections Commission, those who are pursuing this matter seem completely unfazed by this intense rebuke. Both the Chief Justice acting, the Honorable Mr. Justice Navindra Singh, sitting in the High Court, and Chancellor acting, the Honorable Roxanne George, along with Justice of Appeal Rishi Prasad and Justice of Appeal Nareshwar Harnanan, were very strong in their language in describing the nature and quality of this case. I'm speaking about a total of 4 judges. They all use the term unmeritorious, an abuse of the process of the court, completely baseless. These are not ordinary adjectival descriptions that judges would normally ascribe to litigation that come before them. The litigation has to be piss poor, for want of a better word, to attract that type or those types of label. This case has attracted it. And rather than accept defeat and express some form of contrition, the litigant plods on. And this litigant is an unsuspecting citizen of the country, Crystal Fisher. She has already, unfortunately, attracted a cost bill of $4 million. I don't know who this individual is, but she is some person in region number 9, a member of our indigenous community, I think. This poor woman, I think Crystal is a woman, I don't know how and where she will get $4 million to pay, but those who are the intellectual authors and instigators of this claim do not seem to care that they are putting this woman at great financial risk. If the matter goes to the CCJ, the costs will run into millions, unfortunately. And it would appear that Crystal Fisher is the one who will eventually have to bear these costs. But of course, I will make representations if the matter reaches there, that at least the lawyer should assist in bearing some of the costs. I say that to say that they hurriedly, in their quest to seek publicity, published in the press that they have filed an appeal to the Caribbean Court of Justice. So they want to say it, and they want the public to know that they are appealing. Unfortunately, well, not unfortunately, let me say expectedly, the documents that were filed at the CCJ were incompetently filed and incompetently done. So they couldn't get the appeal right. So you could imagine what will follow in the court. If you can't get the appeal documents right, I don't know how you will argue the case when it eventually comes up. And the court has already sent an email out indicating that the documents filed are defective. So that's what you're dealing with here. Abuse of the process of the court, and it being done with impunity. And the leader of this political party happens to be a lawyer. Happens to be a lawyer. The least I say about that, I think it's better for all of us. So we have just concluded the election of chairperson and vice chairperson for at least 9 of our 10 regional district councils across the country. We have completed 9. And I heard questions being raised about the use of secret ballot as the method of electing the chair. Let me say that, first of all, secret balloting is a standard operational procedure for elections of almost every type. The relevant legislation, the Local Democratic Organs Act, Section 20, subsection 2, vests in the clerk, who is the regional executive officer, the section vests in the clerk the power to conduct the elections of the chair and the power and authority to determine any question arising at the meeting during the election of the chairman. Any question arising during the election of the chairman. A question arising would be the method to be used to take the vote. And the clerk has that power to determine that question. And the clerk at Regional Democratic Council, Region Number 4, in my presence, determined that secret ballot would be the method used to elect the chairman. There is nothing unlawful, there is nothing irregular, there is nothing unreasonable or undemocratic about that process. If we are voting by secret ballot to elect the government and the president of the country, what is wrong with using secret ballot to elect the chairman of a municipal district council? If the clerk decides that that is the method, then the clerk makes that determination. None of these persons are councillors at the time when that question arises. So they can't exercise any powers. They're not members of the RDC as yet. So it's only one person who has official power at that forum, and it is the clerk and those whom the clerk chooses to assist him in the process. And they draw their delegated power from the clerk. So I want to reject any notion out there that there was something illegally done in the use of secret ballot as the method used to elect the chairperson of these regions. Region number 10, the elections are not yet concluded, and they will be concluded in accordance with law. The elections are not yet concluded, and they will be concluded in accordance with the provisions of the relevant legislation. The law is not silent on this matter, and I will leave that issue there for the time being. Mr. Justice Arif Bulkan will be sworn in as a judge of the Caribbean Court of Justice on Thursday, the 16th of October, 2025 by President Dr. Mohammed Irfan Ali at, at the office of the President. He is the third Guyanese to be elevated to the bench of the Caribbean Court of Justice, following the Honorable Madam Justice Desiree Bernard of late and the Honorable Mr. Duke Pollard of late. I think Justice Pollard also passed. So Guyana will be having its third member of that very illustrious court, and the court that serves as our final court of appeal. Late this afternoon, my attention was drawn to a press release issued by the Guyana Human Rights Association. Now, I have spoken at length about this body. This has to be one of the most mysterious organizations in this part of the world. I have never seen an organization operating under the rubric of representing and championing human rights to be so selective, to be so discriminatory, to be so perverse in its public disclosures. It issues a statement maybe once every 2 or 3 months, and then you recall that this organization exists. The worst form of human abuse and excesses take place in the country, and you don't hear from this organization. But rest assured, once it comes out with a statement, you can be assured that the statement somehow is critical of the government. It only issues statements that are critical of the government. So if the government is not in any way implicated, you can have the worst form. When I say government, I mean the PPP civic government. You can have the worst form of human rights abuse and human rights excesses, vulgar violations of the rule of law, legal perversity of monumental standards, and once it does not implicate the government, this organization is quiet. I have pointed out repeatedly that during the 6 months when the certain officials at GCOM, in conspiracy with leaders of APNU and AFC, attempted to derail democracy in this country, defeat the ballots of the electorate, and hijack an entire government, this organization was largely quiet. When they had mayhem on the streets, where people are being violated and beaten by protesters, by marauding gangs, by scrapes or whatever you want to call them, this organization is quiet. When people's properties are being looted by these same persons who are masquerading around the country, protesting some cause, or alleged to be protesting some cause. People's property are being looted, people are being robbed. This organization is quiet. But let the government or the state agency, while the PVP Civic is in government, in some way injures one of those persons, one of the perpetrators, and this organization, you can rest assured, will issue a statement against the government, but not a word to the thousands of victims whose rights, properties, and freedoms have been violated by those marauding gangsters on the road. But they will come out to condemn the police if there is an allegation that the police injures one of these persons. It's against that backdrop that I wish to examine a statement that they have issued, apparently yesterday. It's a statement critical of the Constitutional Reform Commission. And it says this: proposed Constitutional Reform Commission should not be under political party control. And then it recites, it pays great compliment to the previous Constitutional Reform Commission established by the Constitutional Reform Commission Act of 2001. So it pays great tribute to that Constitutional Reform Commission, the 1999-2000 Commission. And it says that, and I don't know how they arrive at this reasoning, it accuses the state, as the PVP civic government, of selecting representatives from civil society organizations rather than allowing the organizations to select their own representatives. And it faults the PVP government for saying, well, it's me, that we may have to review the act to ensure that the new configuration of the parliament, which has emerged from the recently concluded national and regional elections, and amend the act to reflect that new reality in the parliament. It faults the PVP government for moving in that direction. I don't know if the author of this document has comprehension problems, or what is written here is inexplicable. And the reasons are as follows. Firstly, we said from the inception that in this incarnation of the Constitutional Reform Commission, we will, as far as possible, mirror the 1999-2000 model. And by and large, we did that. We said that it will not be politically dominated, and no one party will dominate it. We said that we will take 10 members of parliament, 5 representing the government and 5 representing the opposition. And we will take nominees from important civil society organizations, 10 in number. And that were the core principles enshrined in the 1999 Constitutional Reform Commission. We have replicated it here. And the nominees are not chosen by the government, nominees from the civil society organization. They emanate from those organizations. The author of this document accuses the government and accuses the legislation, the act, of empowering the government to decide who those nominees are. In fact, if you check it sector by sector, this commission may be more broad-based than the 1999-2001 commission. So this is the type of diatribe that this organization issues, and it is carried in the press. I don't know if this organization thinks that despite the configuration in the parliament, we should leave the commission in its current state. How would that be reflective of the democratic will of the people as expressed by their franchise at the last election? Whose interest is this organization representing? Can't be the electorate of Guyana. It can't be the Guyanese population. These people have to be representing some unknown vested interest. But that is what passes as a statement from an organization that bears this important name, the Guyana Human Rights Association. Now, whatever I say with the greatest of respect. I always attempt to recognize the role that persons have played historically, or organizations have played, and no doubt this organization would have played a role in the 70s and 80s, but it has lost its path. I think I've said enough. Let me move on. Today, I am informed that Magistrate Leron Daly at the Georgetown Magistrates Court rejected a no-case submission made by Attorney-at-Law Mark Waldron on behalf of Trevor Ben on one of the charges of misconduct in public office. And the learned magistrate has called upon Ben to answer to the charge. In other words, to lead a defense. Ben obviously contended that no case has been made out against him when the prosecutor closed its case. The magistrate, after no doubt deliberating on the evidence adduced by the prosecution, made a finding of law that there is sufficient case to call upon Ben to lead a defense. These are one of the many charges that have been filed against Mr. Trevor Benn in relation to state lands that were illegally and deliberately dealt with by Mr. Benn. In this particular case, it involves 6 acres of land at Plantation Ogle. And the charges are in the public domain. I don't want to get involved in the detail of it, but I thought that I will bring this to your attention because, you know, the Defense Counsel, they run with these matters whenever a case is dismissed. That is the first thing that reaches the press. And when the state, you know, succeeds in some endeavor in these cases, you never hear from, you never hear about them. You never hear about them. So, Mr. Benn will be in the magistrate's court to defend this and many other charges which are currently pending before those courts. Let me see. I'm looking at your comments. Remember to share the program. Share the program so that all your friends and all your followers can join us in tonight's discussion. I'm looking at your comments to see whether you want me to address anything I said to you. That I will try my best to answer any questions you may wish for me to address or to answer any query. But all I'm getting are greetings from all of you, which I appreciate, but I am not getting any questions. You're not asking me any questions in relation to any issues that you want me to address. So that means that you don't have any questions, which is a good thing. And it means that you understand everything that I'm saying, which is also a good thing for both of us. As I said, I always want this program to be interactive and to be educational. And I try to make it that way so that we learn from all, from the exchanges that we have. There are some other issues that I wanted to, at some point in time, in the near future, I'll dedicate a few sessions of this program where we will discuss the elections and the election results. I have to spend some time in discussing because I need to revisit a couple of matters. But as I said, and let me conclude the program on this note, throughout the elections campaign and on this program for the last 5 years, you would have heard me condemn racism. You would have heard me condemn those who are peddling racial and ethnically dividing rhetoric. You would have heard me mention the names of the main perpetrators. You would have heard me appeal for national unity. You would have heard me appeal for us to break the back of racial voting in this country. I did that at almost every meeting at which I spoke. And I said that once we are able to do that, in particular in region number 4, we will win the region. And last week, Friday, we won RDC region number 4 for the first time by taking both the chairperson and the vice chairperson position. You see what unity can achieve? The regional democratic organ system was brought into force in 1980 by virtue of the Local Democratic Organs Act. That was the act that brought into being the 10 administrative regions of our country and the 10 regional democratic councils. And since 1980, that's how many years? 45 years? For nearly half of a century, we couldn't and we didn't win the chair of region number 4. And because of the unity platform that we campaigned on, because we went into every single community and we appealed across racial divides for persons and all of our people to hold hands and to unite, we were able to achieve this objective and we were able to take the region. I will talk more about this and about the work that we need to do going forward in further unifying the peoples of our country and the communities of our country. You will see the tremendous successes and progress that would be achieved now that we control the Regional Democratic Council of region number 4 for the first time. Imagine what will happen if we are able to take Georgetown municipality at the next local government election. That is our next objective. And of course, we will work hard. And with your support, we can also achieve that objective. We will do it one step at a time. I want to thank you very much for spending the past hour with me. I believe that we have covered a wide range of important issues. And I want to thank you for being with me. Thank you for sharing the program. And thank you for all the comments that you have made. I will see you next week. Please take care. Enjoy the rest of the evening. Stay safe. And we will meet next week. May God continue to richly bless each and every one of you. Thank you and good evening.